Hello, law students. This is Mrs. Politsky, and I have your notes for Chapter 3, Section 3, State Court Systems. So, the structure of the state court system, most state systems resemble that of the federal system. So, when we look at the state court system for the state of Nebraska, it basically it has some general jurisdiction. It is tiered, and it has a three-tiered system, meaning the bottom would be your geographically based trial courts. That could be primarily at the county level or district level in the state of Nebraska. Your middle layer is your appellate layer, and the highest court is your state Supreme Court. And Nebraska State Supreme Court is actually located in the state capital in Lincoln. And this is a photograph down here at the bottom right-hand corner of the chambers. So state trial courts, they have general and original jurisdiction over both criminal and civil cases. And circuit courts, basically superior courts, district courts, or courts of common pleas, that's the kind of stuff that we're talking about. But the court record is basically the accurate, detailed report of what went on during the trial. A lot of times this court record is used for an appeal. Sometimes that includes your transcript. State trial courts also review the decision of the court of more specialized jurisdictions under them. When we talk about the state trial court, it has original jurisdictions over the cases before it. It therefore makes determinations of the facts in the case by using juries. And without a jury, the case's proceeding judge would have to determine the facts. Some of this might be based on dollar amounts. So if a case is for like a civil case, a civil dispute, and it's not necessarily something that is all that costly, meaning just a couple $1,000s, that might not necessarily require a jury to be present. But when we talk about court cases that might deal with several thousands of dollars, this is a situation where we might see a jury being called into play. State courts of appeals, the appeals court will review, basically it will be formed of a panel of judges from the state courts of appeal, usually consisting of roughly 3 people or more. In Nebraska, you see photographed there are basically 6 judges. Many courts use multiple judges at one time to sit together to make these determinations, but they evaluate the record and they consider the attorney's oral and written arguments. Again, kind of like the federal level, there's no new evidence, no witnesses called. So no evidence can be submitted at the lower levels. If the case is proven correct with the court or trial court's decision, the judgment may be entered to consider the correct law. Or if the case can be appealed to the next level. So if there's something seriously in question, then it may go to the state Supreme Court. So the state Supreme Court, this is the highest court of the state and the highest level of the Court of Appeals for a state. Cases that involve the most complex legal issues usually are heard by the state Supreme Court. So a justice is a title of a judge who sits on not only the state Supreme Court, but when we talk about the U.S. Supreme Court, that is the term that we use. State Supreme Courts consist of roughly 3 or more justices. In Nebraska, we have 7 who review the legal issues and listens to the attorney's oral arguments. They issue the final decision on the matter of law, appealed to them unless the U.S. Constitution or other federal issues are involved. And if that's the case, then it typically goes through the federal system. If the issue involves the U.S. Constitution, the case could go to the U.S. Supreme Court. That is if they accept that case for determination. State courts that have specialized jurisdiction, you might see a county court or an associate circuit court. County courts, for the most part, they hear like minor criminal issues, traffic offenses, lawsuits involving no more than $25,000. So if you've ever had a speeding ticket, that's probably where it's going to be heard. There could be city or municipal courts. Nebraska is not necessarily one that has that so much, A lot of times what will happen is if we're talking about violations of ordinances and such, that may go through a county court system. But a lot of times this is where you might see an overlap. If you come from a heavily populated state with very large counties, populations, and such, it might actually be easier to kind of have a municipal court just to kind of help hear the cases and to get them through faster, to allow that you can have that speedy trial. Finally, you have the small claims court. This involves minor suits. It handles disputes that are of a small dollar amount, so probably up to about $2,500, probably no more. There are no attorneys that are in this court. The judge alone hears this case and they evaluate the case alone. It kind of reminds you a little bit of if you've ever watched like Judge Judy or some of those TV judges on TV. They pretty much make the decisions all by themselves. Anyway, juvenile courts. This is usually a court that is designed to hear cases for individuals who are between the ages of 13 and 18. It might go younger than that, but this court, for the most part, holds juveniles responsible for their crimes. They have the right to be represented by an attorney. If they are found guilty, the court has the right to determine what is done. So if the court decides that as a juvenile that you need to go through some kind of rehabilitation, they might issue that. Typically, they don't normally send a person who might be under the age of majority to the state pen unless it's a very extreme situation here, like a very high-profile case. But the emphasis typically on juvenile justice is rehabilitation. And part of that is to ensure criminal cases don't become public knowledge. So normally the defendant who is our juvenile, if they're under the age of majority, their case records are going to be sealed. So you won't see their name in the newspaper. It will be pretty much hush hush. And part of that is to give that individual a second chance. All records are not open to the public when we talk about juvenile court. If rehab fails, meaning that we send our youth off to be rehabilitated and they're still struggling, this individual may be tried or punished as an adult. And if the person wants to appeal, they typically appeal it to the circuit courts. Along with that, probate courts, I mentioned a while back, probate courts typically are courts that deal with issues after a person dies. So it's the administration of a will or an estate. Part of that is to make sure that if there's any claims, when we talk about like debt, when a person dies, that the probate court would help determine, who's going to pay and kind of what is owed. That's the reason why having a will is very, very important. So probate, estate issues, that's all kind of figured through this. As far as talking about our juveniles, there are 22 states that don't really have a minimum age for a child to be tried as an adult. So if you take a look here, there are several states here that are kind of in white. Those are some of the states that, basically don't have that minimum age. There are other states that are colored in it, and it kind of shows you the typical age. So neighboring states like Iowa, the age is 14. State of Colorado, it's as young as 12. The state of Kansas, the age of 10. So it's pretty extreme as far as, what is considered to be the age to be tried as an adult. All right. Thank you very much.